The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, everybody. Happy Friday. It is Ask a Lawyer, and it is time for me to answer your questions if you have them, whatever type they are. If I'm able to answer them, I will. I don't practice in every area of the law, but I do a lot of general civil litigation. So what we're going to do, as I've promised, we're going to finally talk about sexual harassment. Yes, that is a juicy topic because I have seen so many fact patterns and handled so many cases of such a wide variety of sexual harassment, from the most mundane and benign to the most disgusting.
Hashtag me too.
Hashtag me too. Hashtag me too, help you.
Yeah. There you go.
So let's start with a little bit of the boring stuff. Sexual harassment is protected against under Title VII of the Civil Rights Act and the Florida Civil Rights Act. My goodness, two of them, right? Why should you sue under one or the other? Well, typically, an attorney is going to sue under both of them. And you could sue under both of them either in state court or in federal court. Most attorneys will sue in federal court. Lots of reasons to sue under both. Lots of reasons to sue in federal court. Sometimes some reasons to choose state court, depending upon the case. The reason you sue for both is that while they both protect you against the same types of conduct, they have different remedies. You can win different things. And where there are limitations on certain types of damages in the federal statute, there are not in the state statute. Where in the state statute you can't sue for punitive damages without getting the judge's permission, in federal court you can. So when you file under both statutes, the jury, if you get to a jury, gets to consider all the potential remedies that are available under both statutes, and you don't lose out on anything that you might be able to get. So that's why you do that. Now, how do you get there? Well, there's an administrative requirement. You have to file what's called a charge of discrimination before the Equal Employment Opportunities Commission, the EEOC, or the Florida Commission on Human Relations. So a lot of people actually do that on their own. It's really very simple. You can Google the charge of discrimination form, or you can call the EEOC and they send you a questionnaire and then they actually prepare your charge of discrimination. Or you go to a lawyer. And sometimes that is usually better. Mm-hmm. Because a lot of times, depending upon the type of sexual harassment, you might want to hold off on the actual charge of discrimination until your lawyer writes a demand letter that says, hey, look, let's settle this thing now, or once we file the charge of discrimination, this thing becomes public.
Okay. And that wouldn't you then know whether or not you have a case right then and there?
Right when and where?
When you call a lawyer.
Not essentially. You know whether the lawyer thinks you may have a case.
Okay.
The more facts that come in, the more the evaluation evolves. So when somebody calls my office and initially, let's say, speaks with my paralegal, mm-hmm. Hello, Cheryl, she knows what questions to ask.
Right.
And she's going to say to them, well, let me talk to the lawyer, and, one of us will get back to you. And, a few times a day, Cheryl and I sit in my office and we talk about calls that have come in. Mm-hmm. And she doesn't tell me names. She tells me fact patterns.
Right.
And I'll ask some questions, and hopefully she's gotten that information. If not, I may tell her to call back and get some information. But from that initial screening, let's say, I have a gut instinct based upon 35 years of experience mm-hmm. as to whether there is no case at all, and, simply explain why. Maybe it's an at-will employment case, or, they didn't really do anything that would constitute sexual harassment.
Right.
Or I think there really may be a case, in which case we're going to suggest that the person come into the office for a free consult.
Mm-hmm.
Or I really need certain facts before I can make that assessment. And I'm going to ask Cheryl to give them a call and just get a couple more pieces of information. So after you call the lawyer, you should have, based upon what you're told, some understanding of whether that particular lawyer thinks no chance in heck,
Mm-hmm.
or yeah, you might have a case, or yeah, you got a great case.
Okay.
Now, let's say you are one of those folks who call in and you're told, whether it's me or by any other lawyer, I don't think this is a case that we're interested in handling. With whatever kind of case you got, sexual harassment, breach of contract, non-compete, doesn't matter. We've talked about so many things in the last 10 weeks. I beg of you, for your own good sake, call a second lawyer. It is always good to get a second opinion, and most of these screening calls, at least, are free. Another lawyer may have a completely different perspective, a completely different idea as to how to handle something. I wouldn't take no for an answer until you've heard it at least twice.
Okay.
Some people go for a lot more than that,
Mm-hmm.
and it's not necessarily wrong.
Yeah, 3 times the charm.
That's right. And in fact, when we're settling, when we're negotiating, and somebody comes, one of the attorneys come back to me and they say, well, this is my client's best offer. I take the offer, I contact my client, and I say, look, they say this is their best offer, but until I hear no 3 times, I don't believe that we've pushed them as far as we can push them. So we go back and we say, no, here's a counter offer. Well, I told you that was our best offer. All right, take it to your client and let's see where we go. And until I really have heard 2 or 3 times, no. I'm not going to tell my client, I think we've done as good as we can do in at least pre-suit negotiations. Your choice is to accept this money, or let's file either a charge of discrimination or file the lawsuit, depending upon where we are in the process.
And I'm sure that a compromise will come to be.
Well, more than 90% of the time, yes, a compromise will come to be. Not necessarily pre-suit. Very often it may literally be on the courthouse steps, or it may be in the mediation that the court always orders before you can go to a trial, when both sides have gone through discovery.
Yeah, you're almost there.
Yes, a lot of time and money's been expended.
Yeah.
And a good mediator is able to put pressure on both of you in separate rooms to come up, come down, and try to get to a point where you both have entered the same window and you will begrudgingly say yes.
Right.
That's the mark of a good mediator, frankly. But if that doesn't work, you have a trial. And we can talk about trial either at the end or next week probably. But that is, depending upon how much an employer wants to fight it, you can go all the way to trial. Some employers know what they've done is wrong when they see it on black and white, sometimes in color photographs. And they don't want it going any further because they don't want it becoming public. They want to keep it confidential, whether it's from their wife or from the public, depending upon the business they're in.
Yeah, because that could change the opinion of, public opinion.
Exactly. So, we'll use that. And very often in my practice, when we have a good sexual harassment claim, we will put an ad in the newspaper, a big ad. Have you been sexually harassed by, in the name of the company? Now, we have to get that approved by the Florida Bar first, any advertising. But once the bar approves it, I am immune from a lawsuit claiming defamation or anything else. So we get the bar's approval, and now this company sees a half-page ad. And there's 3 reasons for the ad. I usually say there's 2, but nobody's listening except us, so I'll tell you the third. The 2 reasons I usually tell people are, the first is truly to see if there are other witnesses that may help corroborate your claim. The second is there may be other people that are claimants that want to come forward and sue as well. And both of those are wonderful things. The third is pressure. Seeing an ad like that is not something most companies that have to deal with the public want to see. And very often, either the threat of it in a demand letter with a copy of an old one I've used, so I'm not bluffing, will work, or actually doing it will say, let's settle this quickly. Sometimes it doesn't. So, yes, you call in first, And I would suggest to anybody out there, and this really applies to all types of law, if you think there may be a problem, call a lawyer. I mean, as bad of a rap as lawyers have, that's what lawyers are for, okay? Your arm hurts, you're going to go to a doctor. You break your foot, you're going to an orthopedic. If you think you have a legal case, call a lawyer. The worst that can happen is you're told you don't. And when it comes to things, let's just deal with sexual harassment. These are situations where mostly women, not exclusively, we'll talk about that too, because it's not really a gender issue, it's a power issue. Whoever is the boss has the power over the subordinate, but generally women. It is a sensitive matter. It is often an embarrassing situation. It is one typically the woman doesn't really want to disclose or talk about. And sometimes that creates a situation in which they continue to subject themselves to ongoing harassment instead of finding a way to nip it in the bud. And very often, sometimes they will do things that are tragic, like quit before they've ever talked to a lawyer. And then when they call me, they tell me they never complained about it because they didn't want to talk about it to anybody else. And I tell them, well, the Supreme Court has said you need to complain or you can't sue the employer for what another employee, even a supervisor, has done.
But see, I would assume that if you handled the situation in the way that you thought you needed to handle it and you left, that to me that means it's done.
Well, it's done in terms of you may not have a claim.
You've dealt with the problem,
Yes.
though. You've eliminated the issue in your life.
But you haven't eliminated the fact that you have been sexually harassed if that's what's happened, okay? If you've been fondled, if you've been called all sorts of sexually derogative names, if your boss has tried to date you, if he's taking you out to lunch and giving you alcohol, you may have quit and left, and you've ended that situation, which is good. But if only you had ended it a week earlier with an email that said, I object to all these practices, stop it immediately. And then you leave. Now at least you've complied with something the Supreme Court has said you got to do. Now there's one exception. We'll get to it. But 90%, you've got to complain.
I would think it'd be hard to go, well, you didn't even let this person know that you were bothered by this
that
action,
person.
And here you're suing them. That comes out of the blue for them.
Right, but more important is the employer, okay? Because the employer who was actually sued under Title VII and the Florida Civil Rights Act. And a lot of larger employers, even medium-sized companies, have handbooks. If the handbook says we prohibit sexual harassment, we prohibit discrimination, and in the event you feel you've been discriminated against, here's what you need to do. If you don't follow their procedure at least approximately, the Supreme Court will say you did not avail yourself of the remedy that the employer was offering so that the employer can have an opportunity to investigate and take, magic words here, prompt remedial action. And so then the court says you cannot sue that employer. They have a defense. You sue them, the case will get dismissed. Now, do you have a case against the person who did it to you? Sure. Not for sexual harassment. You may have it for battery if you were touched. But then again, very often that person isn't the deep pocket. It's the company that's the deep pocket. So you want to preserve the claim against the company. So if you're even worried about it, I would say call somebody. A lot of people that will call my office that have really, really sensitive issues of sexual harassment, they are happy to talk to Cheryl rather than me initially. It is tough sometimes to talk to a guy about what has happened to you. And that's fine. I mean, we'll talk to them in my conference room, and I'll say, look, I'll leave here, talk to Cheryl. Initially, later on, if I take the case, you're going to have to talk to me.
Yeah.
But at least now, you don't know me, you're not comfortable yet. Okay, here's a woman.
And if you're going to court, your
Right.
story's going to be
Right.
before many other people
Right.
as well.
But at least initially, here, talk to another woman if it makes you more comfortable. Or, I'll be honest with you folks out there, if you really want to, call a female lawyer. There are female employment lawyers that handle discrimination. And if that's what you really want, You have every right to it. But men can handle it just as well. And sometimes, frankly, I think a male advocate on sexual harassment is even more powerful to a jury. It's sort of like, well, I would expect that female attorney, without denigrating any female attorneys, be taking your side. But when you got somebody coming out swinging, that is the opposite gender, sometimes it makes a difference. Mm-hmm. And that happens in a whole host of things. I hate to say it, but sometimes you have a white attorney representing a black defendant or a black attorney representing a white defendant. Sometimes that makes a difference. I had a case, I'm Jewish. I had a case where I represented an Arab and a German. Let me tell you, I made sure the jury was aware of that at trial because it's odd. And although I couldn't say it, you're not allowed to put yourself ask the jury to put themselves in your position. I made clear that the inference was, why would I be representing an Arab and a German if I didn't really believe what had happened is true? And sometimes those are the tactics you use, and they're powerful. And there are some very good lawyers who know how to use those tactics, better lawyers than I, in jurisdictions far, far away. That's either a weird sound, a gong. Somebody is trying with this big thing, in the Gong Show to pull me off the radio, or it's a phone, or maybe somebody's calling in. Who knows? But we're going to keep on going. All right. So you got two bases for the lawsuit. You need to call a lawyer. You need to call a lawyer soon. You only have 360 days in Florida to file a charge of discrimination from the date of the last act committed against you. I know that's not quite a year, but the reason it's 360 is because the federal statute says 180, but in jurisdictions where you have a state statute as well, it gets doubled. So 360. So let's say it gives us some time to work with. You come in, you may still be employed. Mm-hmm. And the statutes protect you against retaliation. So a lot of women, I'm going to use women, it could be men, but a lot of women will come in and say, what's going to happen to me once you send this letter that says I'm suing you for $1 billion? What are they going to do to me? They're going to fire me? I hope so. Because you have such a better claim now. You have a retaliation claim under the statute. So what I really explain to them is...
Let it play out.
Let it play out. It may be a little bit uncomfortable, but how much more uncomfortable can it be than what you've been subjected to?
Right.
They're not allowed to retaliate. I let people know, look, there are obvious ways of retaliation, which if it happens to you, we can prove. Mm-hmm. Then there are subtle retaliation, which cannot always be proven. And that you may have to just subject yourself to dirty looks, sneers. It's hard to prove. But if the comments continue, if you're moved to a different position, if your salary is cut, if your hours are cut, if you're fired, you've been retaliated against. And here's the fun thing about retaliation. You've complained about sexual harassment or racial discrimination or age discrimination or disability discrimination or pregnancy discrimination, any of the discrimination issues. You've complained because you think you've been discriminated against. It turns out in reality, let's say before a jury, you haven't. You lose that case. But they fired you. You've now just won a retaliation case. Both those cases go on simultaneously. So even if you really weren't discriminated against or harassed, but you thought it constituted that, and you complained and you were punished, you're now going to have the same damages available to you for retaliation. Mm-hmm. So, sometimes if you really don't want to work there much longer, I say, well, go back and hopefully you'll be retaliated against. And then you'll have a double claim. Sometimes if you really, and I have a client right now, desperately does not want to go back to this office once I make clear that they've gone to a lawyer and they're now making a claim. Mm-hmm. And they don't even want to file a complaint. They've never complained to upper management, which they've got to. And they don't want to do that and still work there. They're afraid. So we came up, you talk, this is what you talk to a lawyer about. We came up with a strategy, which hasn't been implemented yet, so I don't care about saying it because nobody knows who I'm talking about. Where about a week before they are going to leave, I am going to have them both send an email to management saying, this is what has been happening to me. It is untenable. I can't tolerate it anymore. I'm taking 3 days of personal time off. I'd like you to investigate it while I'm out. Usually, I think I know this employer, it's not going to happen. And then the client, through me, will send a letter saying, we're not returning. You haven't done what you need to do. You haven't conducted the investigation. You haven't even called us to talk to us about it. We're not leaving. We're not coming back. We quit. Now at least I have set up a scenario that is easy to defend in court, that you have complained and then you left. Much better than if you just leave. Mm-hmm. So lots of reasons to talk to a lawyer about strategy. Now, can anybody claim sexual harassment if, since this is sexual harassment and even the courts allow you to use terminology that courts normally would not, but I know we're on the radio. But my understanding of the reality right now is, although some broadcasters don't like you to use words, so I won't.
Well, there's a certain...
That there is no law anymore.
There's certain words that you can't use.
That's actually not true anymore. Actually not true.
Oh, I don't
but
know.
I won't go there. I won't go
Protect
there.
my employment.
All right. So let's say you're a woman and you are repeatedly being touched inappropriately.
Oh, that would happen once. That
Good
would
for
not
you.
happen again.
Good for you.
Yeah.
Does that constitute sexual harassment? Maybe.
It depends.
The statute says that you have to have at least 2 instances within a reasonably proximate period of time. So one can't be in 1972 and the other in 1997. But you're touched twice within 3 weeks? Probably. But now what else is necessary?
Now let me ask you this. Would hand kissing, you know how a long time ago gentlemen used to kiss the hand of the lady, in today's world, would hand kissing be a bad thing?
If that was all that happened, I would think that it would probably be a relatively weak case, a possible case, probably not one I want to put my contingency time and 500 hours into, okay? But if the intent was not to offend, and you were offended, which you have every right to be, I guess the question is then, did you explain that I don't appreciate that, and was it continued?
Okay.
Then we're getting closer to sexual harassment.
Okay.
But if you have somebody, I'm going to stereotype, folks, I'm sorry. If you have somebody of European background and they believe in, kissing the hand, and they believe it's a sign of respect and, honor, and
wave hello from afar and walk away.
And you don't say anything, then you're probably not being sexually harassed.
Okay.
If you say something and they continue, you're getting there.
Okay.
But the other thing is, it's not.
Now, how about this person does this to everyone? Then it's really not.
He does it to the guys too?
Well, I don't know. This was a long time ago.
Something. There's this idea, and it happens a lot. If you got somebody who is doing it to everybody, males and females, it's probably not sexual harassment.
Yeah, they're just
because it has to be based upon gender.
Yeah.
If they're an equal opportunity harasser, then they're probably going to fall into the category that's called bad employer syndrome, bad boss syndrome. And you may not have a claim. But a lot of employers will want to settle that anyway because it just looks really bad.
Yeah, it's just goofy.
Does anybody have a claim? You work in a company that has 5 employees. Can you sue? What happens in that company? You're working with 5 employees. Every day, your boss is coming up to you and feeling you up, getting you to climb ladders and looking under your dress, making comments, suggesting that if you have sex with him, you'll get a promotion or a raise. Boy, that really sounds like sexual harassment. Unfortunately, The statute, both Florida and federal, the company has to have at least 15 employees for these statutes to apply. So what happens if the company has 14 employees and that happens? Guess what? Legally, you have not been sexually harassed. Now, you've been touched, so you have what's a common law battery claim. Might really piss off a jury, and you might get some decent damages. But you do not have a state or federal discrimination/harassment claim. The employer didn't have enough employees. Why did this happen?
Wow, so the employer can be a total jerk.
Yes.
He just doesn't have enough employees
That's
for you to
right.
complain.
Absolutely.
Wow, that doesn't seem very
I can do
fair,
whatever
does
I
it?
want to Cheryl, and I can get in trouble, but she can't sue me under Title VII of the Florida Civil Rights Act. Cheryl also, once, and that would be it.
Yeah.
And then probably she'd call my girlfriend too, so I'd really be in trouble. But the reason when this was all passed, first of all, everything is compromise and negotiation.
Mm-hmm.
And thank goodness, at least when they passed Title VII of the Civil Rights Act, as amended, but started about in the 60s after Kennedy was assassinated, Johnson took over, the portions of the Civil Rights Act started to get passed. This is one of them. Congress's perception was we don't want to overburden small employers with potential litigation like this. So we set the threshold at 15. Do I agree that that's a good threshold? No. Do I think that a 2-employee company should probably be subjected to something like this? No. You know, if I were Mr. President Dictator and I can do whatever I wanted, I'd probably say 10. Others might differ and say 5, but Congress said 15, which is interesting because on another topic that we will approach one day, the Family and Medical Leave Act, the threshold is 50 employees, 50, within a 75-mile radius of where you work. So if that employer has separate offices, you can add up all those offices within 75 miles, and if you get to 50, you have an FMLA claim. Title VII, which is discrimination, 15. There are other statutes that have other numbers, which is why you ask a lawyer, because you're not expected to know all that, and honestly...
And who would have even known that those types of rules exist?
Right, and you know, that lawyers don't always know these things off the top of their head unless this is really their practice area. But it's easier for a lawyer to research it and figure it out, because if you have a decent lawyer, you know how to do the research. You as the layperson aren't expected to know this or understand this. You know, if my sink started spewing water, I would not have the foggiest idea of what to do. You know, my girlfriend...
You'd ask a plumber.
Well, my girlfriend's teenage son knew how to shut off the water. I didn't even know that. So everybody needs somebody sometime. I think there's a song like that.
Yeah.
But it's true. So in these situations, call a lawyer. Now, so that's the 15 employees. What happens under 15, like I say? You may still have some claims, and you should still talk to a lawyer. They're not sexual harassment, discrimination claims. They may be battery. They may be invasion of privacy. They may be a number of things, but they're not this. I mean, in reality they are, but legally they're not. Okay. So what types of sexual harassment do we have? And I don't mean what different types of touching and words. At least I don't mean that right now. There are 2 essential types of sexual harassment claims. There is the traditional hostile work environment, and then there's quid pro quo. Nice Latin. Hostile work environment, fortunately, is the most prevalent type, which is sort of what we've been discussing. Nasty jokes, dirty jokes, sending emails, texting you a photo of his genitals to sort of entice you. Let me tell you, some of those photos are not very enticing.
Then you'd have
seen
concrete proof that you're being harassed.
Oh, I love that.
Yeah.
Oh, there are sometimes lawyers salivate.
Go
when
ahead,
clients
send that
come in.
picture.
Yeah, there are sometimes lawyers salivate,
Yeah.
and it's not just a he said, she said. And the more evidence there is, the more wonderful it is. especially when it comes to demand letters. And if you get to a jury blowing these things up into monster poster sizes. One of my cases against Publix more than a dozen years ago, I was using, terminology that I'm entitled to use because it was things that were said. But after about a day of this 2-week trial, the judge, who at that time happened to be the chief judge of the Southern District of Florida, said to me, Mr. Address, the jury gets your message. Can you please just say the F word? I said, yes, Judge. I'll call it the F word. Doesn't have the same impact, but you've just told me to do it, so I guess I got to do it. But no, he wasn't going to allow me going 2 weeks saying F this, F that, unless I just said F this, F that. And I was using other terminology too.
Yes. There was enough of that in the court,
Yes.
right? Yeah.
Yeah, I was using a lot of terminology in that courtroom, and the judge was coming up with different euphemisms for me to be instructed to use after the jury had heard it a few times.
Yeah. So that person who was subject to all of that really had a case.
Yeah. And interestingly, that case had an interesting ending. And it's one of my war stories here, so maybe we'll get to it. So that's hostile work environment. You're treated horribly. Nobody's demanded anything of you. They may have asked you to have a date, but nobody has suggested that your job's on the line. That's hostile work environment. A lot of people will call my office and say, I have a hostile work environment. And we ask, well, what do you mean? My boss calls me horrible names all the time.
Like stupid?
Like stupid.
Oh.
Now, here's the law.
Here's the thing, though. Maybe you are?
Yeah, it doesn't matter.
No, okay.
Here's the law, folks. There is no law, federal or state, against having a nasty boss.
Okay.
It's called bad boss syndrome. The courts actually have a name for it. It's in written opinions. There is no law that protects you against it. If you have a nasty SOB as a boss, you have two options. Take it or quit. That's rough, but that's the way it really is. It has to cross the line on a number of levels to get into a legal matter. And so,
well, the end is near anyway. One way or another, you're either going to say something and get fired, or you're going to find a new place to work.
And then call a lawyer.
I would try to take it over that person's head if it was possible.
Yes, that's the idea. You can't just complain to the harasser unless the harasser is like the owner of the company.
Right.
But
then you might as well speak your piece because it's not working out anyway.
Right. You should say no to the harasser as soon as it starts. Yeah. But at some point, you need to go higher. Some companies have a human resources department.
Right.
I'm telling you, you need to go to human resources. A lot of companies, like Publix, has an 800 number where you don't even have to give your name. They give you a code that shows you called. Now, there's proof that you called. And for a while, nobody really knows who you are. If you don't comply with those things that are in employee handbooks, you're going to severely damage your own possible case. And so it's important early on when this starts to happen to you, call a lawyer. If I call a plumber, it's going to cost me some money just for the call. Call a lawyer. You're not going to pay anything to at least chat, at least with the paralegal for a bit. So I see we do have a caller. Oh, my goodness.
It's your number one fan.
Why are you doing this to me again? Hello, Bubby.
I have a question to ask.
It's embarrassing when the guy's mother calls 2 weeks in a row.
You don't have to tell everybody it's the guy's
I'm an honest lawyer, remember?
Okay, my question is this. I've been out of the workforce
for a long time.
For over 50 years.
Yeah, a long time.
And in my day, when you got a pat on the backside, it was lovingly. Was that considered sexual harassment in the 50s?
Well, since there was no statute back then, the answer is no. Also, you're right. It was a different era, and that may have been intended to be a polite congratulations, or it may have been a lecherous old dirty man.
No, we considered it a very lovingly gesture.
Well, kudos to you. If it happened right now, I don't think most women would take that as a loving gesture.
Okay, then today it would be considered sexual harassment.
Well, it would be considered the beginnings of a possible sexual harassment claim. If it happened
what
once.
What a world we live in.
Yeah, what a world we live in.
Okay, son, keep up with your good work.
Thank you, Bubby.
Bye-bye.
Bye-bye.
Have a good day.
Thank you. You too. By the way, she's called Bubby because in Yiddish, Bubby means grandmother. So my son calls her Bubby. I called my grandmother Bubby. So I refer to her when she's calling as Bubby. More information than you need to know about me. But then again, a lot of my clients know a lot of things because they play into whatever type of case they have. And it makes it more personal, more relatable. I mean, I can't say that everything that's happened to them has happened to me, but there are areas in which you can relate. So, Bubby, don't call next week, please. All right. So where were we? That's the hostile work environment. Then there is quid pro quo. It happens less often, or at least it's reported less often. It is probably, in my view, the most despicable, insidious type of discrimination that one can suffer. And that is really when it is made clear to you, expressly or by implication, that your job, a promotion, salary, whatever, is on the line in exchange for sexual favors. So that's quid pro quo.
How do you prove that, though? How do you prove that one?
Well, you prove it the same way you prove hostile work environment. Sometimes people have seen it and heard it, and they'll testify to it, especially if they're a former employee.
You got to wear a wire.
No. In Florida, you can't do that. Florida's a two-party state for wiretapping, and if you wiretap somebody without their knowledge, it's a felony. So don't do it, folks. Don't do it. Federal wiretapping law is a one-party.
No, I meant like on your body, like
Well, that's what I mean.
On TV, the cops do that.
Use your phone.
Yeah.
Can't do it.
Really? You just
In Florida is a two-party consent state.
Okay.
Unless you tell somebody you are taping them, and they really have knowledge and there's no objection.
Can you tell them after you already?
No.
Okay, that doesn't work either.
It is a felony.
Okay.
Okay.
Don't do that, folks.
So, now if you happen to be, under federal jurisdiction, then it's okay. Federal law is a one-party. If you yourself consent, you can record. There are plenty of states that follow that federal model. They're one-party states. So secretly, anybody can record anybody. Florida is a two-party state. Okay? Both parties to the conversation have to consent or you cannot record. It's why whenever you call any company, this call may be recorded for quality control purposes. Baloney. It's not for quality control purposes. It's for evidence. Okay? But they've told you, and if you continue with the call, you've consented.
Right.
Okay? Just like all those terms and conditions that nobody ever reads because you got to sign them or, you can't have the Microsoft product.
Right. Or that app on your phone.
Exactly. So quid pro quo, it's proven in the same way. Either you have witnesses or there is some demonstrative evidence, photos, or I don't know if I mentioned this on the radio or not yet. I had one client once who had been subjected to this several times, the boss demanding sex. And she finally told her husband. And the husband, instead of going there and shooting the guy, we're going to have a call right in the middle of that line. Stay tuned for the rest of the story. We have Larry on line one. How are you, Larry?
I'm all right. Listen, I broke my left arm, my humerus bone.
Okay.
May it'll be 3 years. I was seeing a specialist for my arm for 14 months. And instead of doing surgery or anything, he said he wanted to try to heal it on its own.
Okay.
And the treatment was eat more vegetables and everything. He never set my arm. He never done nothing. other than put a brace on it just to protect my arm.
Okay.
And anyhow, I fired him after 14 months.
I don't blame you.
And I tried to get another doctor, and Dr. Epstein, and he took a look at it. And he says, "I can't do anything for that. You need a specialist in that area."
Okay.
And then from there, I couldn't do. And because it was 14 months with the one doctor, I tried to sue him. And everybody tells me that there's 2-year statute.
Okay, there is a 2-year statute, but the 2 years either runs from the time you should know that you may have a claim, in this case, of professional negligence, malpractice. And sometimes that 2 years can be extended, if you're undergoing certain treatment and trying to resolve it. Only a lawyer who deals regularly in personal injury and even medical malpractice knows all those ins and outs of the exceptions. See, I don't do that kind of law. I do know, that there are exceptions, but unlike hearing discrimination, I couldn't tell you off the top of my head all the possible ways to get around that 2-year statute of limitations. I would also tell you, though, that while, to me at least, it sounds like this doctor was a quack, in order to have a medical malpractice case, I know that under Florida statute, you have to have, usually your lawyer, get 2 other doctors to sign affidavits that they believe that the other doctor's behavior fell below normal standards of care. It's a requirement, it's a pre-suit requirement to filing a lawsuit, just like filing a charge of discrimination is a requirement before you can file a discrimination claim. And
I don't know how much time you leave, but the problem I had was even the other doctor that said he couldn't do anything,
right,
would not say that the doctor was malice. I mean, it seems to be that wherever I go, they're specialists, but they're not a specialist in this area, and that's
in the humerus bone.
Yes,
I don't know what
it was totally shattered.
I mean, look, I'm not a doctor now, but I would think that most orthopedic surgeons would be able to handle, even a severe destruction of a humerus bone.
Well, they tell me the one guy told me it's really, out of everybody's league. But he wouldn't say the doctor did wrong.
Let me make one on the medical side. Let me make a suggestion to you. I don't know what specialists you've been going to. I don't want to know. We don't need to use names.
No, I know.
But if they're local ones, before you first of all give up on your medical condition, which is much more serious than the legal claim, honestly, maybe try a major place like Cleveland Clinic or Jackson Memorial or the Mayo Institute.
Yeah, they've got. My University of Miami at Jackson's got.
Try
world
some
class. Yeah.
Try some of these places that have specialists that are tops in their field, because that sounds odd to me. That they can't do something even for a shattered humerus bone.
Yeah, but as far as a lawyer, even I couldn't get anybody that would take the case.
And that's not uncommon. It's not uncommon that a medical malpractice attorney, when doing a screening like I do in any other case, might think, well, this sounds like malpractice, but it's going to be hard for me to get other doctors to really go on the record for this type of thing. Vegetables,
But like you said at the beginning of the show, if you're told no once,
right, exactly,
call another attorney.
And the more important thing is, call 2 or 3 attorneys. Meet with 2 or 3 attorneys.
Everyone that I see on TV. And I finally got one that was interested, and they said they thought I had a case, but they didn't have enough time to set it up. So I'm saying, I got 14 months with the one doctor. I can't sue somebody that I'm seeing at the time, And I knew it was going nowhere.
And again, I don't know the exceptions, but I would suggest not only do you go to a larger facility with better medical specialists, but that if local attorneys that do medical malpractice in St. Lucie County, let's say, or Martin County, are telling you this, I would say go to Palm Beach County, go to Broward County, go to some of the larger law firms that do medical malpractice, because they may have a different perspective.
Right.
And they may know a way around the statute of limitations if that is really a problem.
Yeah, because I tell you, if you see me in person and I lifted my sleeve up on my shirt, you'd be amazed what my arm looks like. I can't even use it.
There are lots of things I've seen, even though I don't practice in that area, that are saddening, and I feel for you truly, to have that kind of a disability. I hope you can get it resolved, or even if it's not fully fixed, resolved to an extent where at least whatever pain you're in is lessened.
So personal injury.
Personal injury, but not just any old personal injury lawyer, one that does medical malpractice, professional negligence.
So, Larry, we hope that helps you out.
I appreciate it, and thank you for your time.
You're very welcome, and good luck on both fronts, the medical and the legal.
All right, thank you. Very
You're
nice
welcome.
talking to you.
Okay, well, that was interesting, and that's troubling. It's also a reason to call a lawyer earlier rather than later. But I do understand why he waited. Sometimes, unfortunately, even I get calls and clients, whatever the type of situation, have waited just too long.
Too long.
And, you feel bad telling them that, but sometimes the statute's the statute, and there are exceptions. I can go into all sorts of complex things that nobody wants to do on a radio, the discovery rule, and all sorts of exceptions that lawyers can try to utilize, sometimes successfully, to avoid a particular hard statute of limitations. But then there are some you just can't avoid. All right. So the quid pro quo, I had one of my clients we were talking about. After she told her husband, the husband decided he was going to hide in the closet in the apartment with a video camera. The boss brought the wife back to the house. Of course, they weren't going to allow him to have sex with her again.
But he didn't know that.
Well, he didn't know that. But the husband and the wife had concocted a scheme, without help of a lawyer, thank goodness, whereby they were going to
catch him.
They were going to let it go to a certain extent, enough on video camera to make the case. And then the husband was going to pop out and say, get the out of here now. And that's what happened. And when the client, came to, at that point I was working, I think I did mention, I was working for another law firm, Rubin & Rubin. And she asked me when I watched the videotape to go into the conference room alone, lock the door, so that nobody else in the office could possibly see what I was going to see. And I understand, very private, very personal. It's not exactly what you want to have broadcast, even to my paralegal. But, as Supreme Court justices do when trying to determine obscenity, I had to watch it. And I watched it. And my recollection is that case settled. The more graphic the problem, the easier it is to settle a case for good money.
Yeah, she should own the company.
Right. And there are similar cases. I mean, I think I may have mentioned a case in which a woman was spanked by her boss that got into a little bit of an S&M category, sort of 50 Shades of Gray. And she went home and took photographs of her buttocks, in the bathroom mirror. And they were pretty bad, pretty bruised.
How did she agree, though, in the very beginning?
All right. It started out consensual.
Okay.
But then when no becomes no, no is still no.
Yeah, but then it becomes if you'd like to keep your job. Exactly.
So what was a consensual, I'm willing to have sex with you. Probably a stupid decision anyway, but I'm willing to have sex with you. Became an S&M bondage situation in his office before she knew what was happening. I mean, she's tied up and, he's overpowered her. And, she told him to stop, and the buttocks were pretty bad. She took the photos. She came to our office. We sent him a demand letter. We had color photos put into the letter. It settled quickly. Okay? We've had cases with auto dealerships, car washes, beer distributors, physical therapists, restaurants. Some of these are, I hate to say run-of-the-mill because they're still important, run-of-the-mill hostile work environment. Some of them go to extreme hostile work environment. Some of them are quid pro quo. And once you start getting into pictures and text messages, as far as I'm concerned, that employer is toast.
Mm-hmm.
I mean, if you don't want to settle early, then a jury will just smack you over the head.
Isn't it amazing how people don't believe that their electronic communication is a record?
I don't know. Maybe the next generation, maybe the kids will understand that next generation and be smarter. But yeah, I still see plenty of it. And the first thing I say when people give me a fact, do you have text messages? Do you have emails?
Mm.
And a lot of times they say, yes. I say, well, let me see them. And it's like, one gentleman, I know we're running out of time. One gentleman, in order to entice one of his female employees, texted her a photo of his genitals. The only problem was his genitals were flaccid and very unimpressive. Why you would text that particular photograph of your genitals if you're trying to entice a woman, I don't know, but that's what he did. So when I wrote my demand letter and I included a color copy of those small, soft genitals, I mentioned that to him in the letter. Why would you even send this photo? It's embarrassing. It's humiliating. And we're going to use it in front of a jury.
And we're going to use it in front of a jury.
And the case settled.
Sure.
Yeah. So, I don't know. Maybe I'll attribute this to the character Tom Hanks played. Stupid is as stupid does.
Mm-hmm.
Or, life is like a box of chocolates. You got nuts everywhere. Okay? And, when I open those boxes, unless there's a diagram, I'm always trying to avoid the nuts because I don't like nuts. I think I deal with enough of them in my office.
They've really done us a favor by letting us know what's inside what piece of chocolate.
Thank goodness. I wonder if I could sue if the diagram is wrong. I don't know.
If you have a nut allergy.
If you have a nut allergy. All right, so we are winding down. We are not done with sexual harassment. Surprise, surprise. We will continue it next week. After that, I think we're going to go into the Family and Medical Leave Act, which also has lots of requirements and is another area that people encounter frequently. It's not like this doesn't happen to a lot of people. And family and medical leave, this happens quite often to males and females. Men are entitled to take time off too, to care for their own medical condition, to care for their wife or significant other's medical condition, to care for their parents' medical condition, their child's medical condition. And men are told no or interfered with just as often as are women in that area. So we'll be getting to that. We'll get to some other areas, but for now, it's about time to sign off. And I look forward to questions, and you can call my office at 772-781-8003. We thank those of you who have called our office recently, and we look forward to hearing from more of you either at the office or here on WPSL. Thanks very much, and have a great weekend.